JJ the CPA here. Hope you're doing well. Employee retention tax credit and applying the rules, the law, to determine who actually qualifies when we're now talking about related individuals, the owner, and the spouse. Now, I'm going to let you know this is a follow-up video to a seminar I did. Ended up presenting for over 2.5 hours and took 3 hours of FAQs. And this video was out of this. If you are interested in now going and seeing that seminar, in the body of this, you can see the link. But the follow-up and this video then is talking about these unusual circumstances where possibly one might conclude that the owners and the owner's spouse may qualify for the employee retention tax credit, retroactive now, of course, to 3/13/2020 for those that got PPP. So this is a monumental development that could be. There is nothing on point to this on the IRS website other than FAQ number 59. So I'm going to go to FAQ number 59. I'm going to then go to the law that it indicates, and then we may draw a conclusion together. So I'm going to go ahead and share my screen with you so that we can go through this together. One of the things I'm just going to note to you for those that took the seminar, or if you're interested in the seminar, just letting you know that I have updated the PowerPoint. You now can watch the full over 5-hour video. I've got the private research video on there. And then anywhere I've got the pink, I've updated. But these are all the things that if you want to watch this seminar, you'll also get immediate access to all of this information. But what's new down here is 3 new sections. We're going to cover, though, this section on the individual, the related individuals and the owners and the spouses. So the first thing to note is that when we go to the law, and here we're talking about in the CARES Act, which CARES Act is section 2301. And when we go to E, which is certain rules apply, it talks about 51I1. This other provision that it indicates is related to another video I'm doing on reporting of the credits. But nonetheless, this code section here is about related individuals. And the IRS then took that and made their interpretation. So this is where we see in the law how we deal with it. So those that attended the seminar, if you get the materials, I have this where I copied it into Word. It makes it easier to read it. But when you're talking about then who it applies to, the eligible employer, but then when we're talking about the qualified wages, it talks about the number of employees. It talks about all the aspects of what gets included in the health care and any kind of allocation related to that, and what wages and what's a decline and all that good stuff. But there's nothing on point other than this code section that is then referenced in section 2301 E of the CARES Act here, where it just says certain rules apply. So where do we go here? Well, what we need to know here is that they do address it, they being the IRS, irs.gov. You go to the FAQs, you go to number 59 for the ERTC section, and it talks about this. And if you'll bear with me, I'm going to read it to you, but I do have where we're going to look at the actual law that it references, and then I'm going to make a note to you about the self-employed. And so I'm going to read this to you, but I'm going to read it while I comment. And when we're talking about this, it says, are wages paid by an employer to employees who are related individuals considered qualified wages? No. Now, I'll tell you this, when I've read through this and when I take into account family attribution rules, which is something that applies across tax law, and then when you take into account the aspects of any kind of indirect or direct ownership, the conclusion that I've drawn, which we're going to challenge, is that the owners and the owner's spouse would not qualify if they own more than 50% of the business. And part of that, I'll just jump ahead, is that the self-employed are not eligible for the employee retention tax credit. Only wages are, and then only to employees. It does indicate for the self-employed that this is referencing the self-employed earnings. But if a self-employed has employees, as the FAQ on ERTC number 23 spells out, that the employees of the self-employed, that those wages can qualify. Of course, you have to meet all the other parameters. But on number 59, it says no. It says wages paid to related individuals, but it then says as defined by section 51I1 of the code are not taken into account for purposes of the employee retention credit. A related individual is any employee who has any of the following relationships of the employee's employer, who's an individual. The first thing you're going to note potentially is that it doesn't list spouse and it doesn't list the owner. Okay, it lists everybody else in their dog, as they would say. You got a child, brother, sister, step, father, mother, ancestors, stepmother, stepfather, niece, nephew, aunt, uncle, all the in-laws that would get listed there. So it says, in addition, if the eligible employer, and when they say that, they mean an employer that's eligible to take the employee retention tax credit, it says, then a related individual is any person that bears a relationship described above with an individual owning directly or indirectly more than 50% in value of the outstanding stock of the corporation. So we have directly and indirectly. Directly and indirectly most of the time means that if I own an entity that owns an entity, there's an indirect type of ownership that would come into play. Indirectly and directly typically also means that a spouse of an owner typically can, in essence, be part of an indirect ownership. Probably comes down to the state, whether it's common law or not, just making an observation here. Then it says right here, if the eligible employer is an entity other than a corporation, then a related individual is any person that bears relationship described above with an individual owning directly or indirectly more than 50% of the capital and profits interest in the entity. So what would be an entity other than the corporation? Well, it'd be an S corp, probably. I mean, typically when we see corporation, it could include S or C, but it doesn't matter. Basically, what they're making clear is that if it's not a corporation, then anything else that's a trade or business, which would include the self-employed, Schedule C, Schedule F. And then down here it says, if an eligible employer is an estate or trust, then the related individual includes a grantor, beneficiary, fiduciary of the estate or trust of any person that bears relationship described above with an individual who is a grantor, beneficiary, or fiduciary of the estate or trust. So that is very, very rare that that would come into play. So we look at this and, this is really all we have to go on. This is the only area in the aspect of what the IRS has put out addressing the issue of related individuals. So it indicated here that 51I, that's code section 51I1, which remember that's what was also that I had indicated to you that's in the law in 2301E, which is the CARES Act. It references that 51I1. So let's go to 51I1. Okay, so 51I1, and for those that attended the seminar or for those that buy the access, if you will, to that web page and you get everything immediately, you're going to get the links to these things. Of course, you can Google it on your own and find it for free as well. But what it indicates here in 51I1, it says certain individuals eligible. It says no wages shall be taken into account under subsection A with respect to an individual who. Well, real quick, let's go up to subsection A. Okay, so subsection A, for the purposes of 38, the amount of work opportunity credit determined under this section for the taxable year shall be equal to 40%. So the one thing to note here is that this is taking a section out of another aspect of the law and applying it to the employee retention tax credit. In essence, 2301E of the CARES Act is saying, hey, we want to reference this other law and this specific section of the law. So part of what I'm pointing out to you is that this work opportunity credit is another type of payroll tax credit. So what is applying out of this is only the aspect of 51 I-1, which is down here. Okay, so I-1. So let's go back. So no wages shall be taken into account that bears any relationship described in paragraphs A through G of 152D2. Oh, okay, we got another code section. Well, guess what? I got it ready for us. So we have to go to code section 152D2. And in this, it indicates that it's 152D2, but then it references A through G in that section, and then it also references H of that section. So when we go to 152D2, and again, you have a link on this on the website, the web page if you have access to it, but it says relationship. So for the purposes of paragraph 1A, an individual bears a relationship to the taxpayer described in this paragraph if the individual is any of the following with respect to the taxpayer. Now, one of the things you'll note here is that really A through G, okay, is what the IRS had on their website, right? So the IRS has put that in there, A through G. So technically, this comes from 152D2. And the reason we got to go to 152D2 is that it's referencing 51I1. Why am I telling you that? Because clearly the IRS has taken 51I1 and then went a step further and is pulling any kind of description from the other code section that's referenced in 51I1. So it is okay for us to go to here. So in case you're not following me or you think, well, why are you going to this other code section? Because 152D2 is not referenced on the IRS website. Well, it indirectly is. So with this, A through G is the same. The child, the brother, sister, blah, 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 blah. You can read right here, right? It's the same thing was on the IRS website. So when we go back to this, we now have taken care of knowing what this. Now it says, or if the taxpayer is a corporation to an individual who owns directly or indirectly more than 50% in the value of the outstanding stock of the corp, or if the taxpayer is an entity other than the corporation. And you'll see this is the exact same language that is included in the IRS. So I'm just pointing out that all of this, okay, both of these things that we're listing here is included with what the IRS has included. So the IRS is including here the language from Internal Revenue Code section 152D2. So when we look at in 51I1, so now when we look at this aspect of it, this also then references also no wages shall be taken into account, blah, 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 who is a dependent described in 152DH of the taxpayer, or if the taxpayer is a corporation of an individual described in subparagraph A, which is this here, or if the taxpayer is in a estate or trust, grantor, that issue comes into play. So point is that this is put into the FAQ, but this indicates that's in what's not eligible is a dependent, okay? But we do have to go look at then, well, what is the definition of a dependent under 152D2H? Because that right here indicates an individual other than an individual who at the time during the taxable year was a spouse, interesting, determined without regard to section 7703 of the taxpayer. So it says it's an individual. If we take out the indication of the spouse, who for the taxable year of the taxpayer has the same principal place of abode of the taxpayer and is a member of the taxpayer's household. So in 51I1C, it says that a dependent is not included, meaning a dependent would be considered a relative that would not be eligible for ERTC. But what it indicates here is that the spouse is excluded. So if that was a bunch of mumbo jumbo, let's just do this. We look here in FAQ 59, it doesn't say anything about the owner or the spouse. It talks about all these other people. We go into 51I1, okay? It talks about what was already in the FAQ, which is, the ownership and related individuals. Then we go to 152, and it lists all of these that are same in the FAQ, meaning nothing in here addresses or excludes the spouse. Nothing in here excludes the spouse. And in fact, it's saying it's an individual other than an individual who at the time of the taxable year was the spouse. So an individual that bears a relationship to the taxpayer is any of these: child, brother, and then including an individual that has the same principal place of abode and is a member of the taxpayer's household. But right there, it doesn't list spouse. And in fact, as I'm repeating myself, it actually says, hey, and by the way, it doesn't include the spouse, because it's talking about same principal abode, member of the family, but they're saying, but the spouse is excluded from that. And then when we go back to this 51I1, related individuals, and then it says, okay, so no wages taken into account with respect to an individual who. It's all those people. And then as it relates to the aspect here, who, if the taxpayer is a corporation, if it's an individual, if it's a trust or an estate, talks about a dependent, which we already talked about. So it's not as though the FAQ just simply forgot to include any language about the owner or the spouse, in essence. This is coming from the law. So from my perspective, I'm still not convinced. Somewhere there's got to be something from the standpoint of the owner and the spouse being excluded. But when we do tax research, and I've talked before, we have to just read it. We can't put our own language, our own wording into what we're reading. We can't put that into the law. All we can do is read the law. And here's how the law is written. Here's how it was described. When we go to the CARES Act, it references the 51I1. It doesn't reference anything else related to this issue. The IRS has put together, in essence, what just comes simply from here. And as it relates to this, let's just read it again. Are wages paid by an employer to employees who are related individuals considered qualified wages? No. Wages paid to related individuals, you would immediately think, well, that must be the spouse. But then it says go to 51I1. We already did it. Doesn't list the spouse. And then you got to go to 152D. We got A through H. Spouse isn't included. And in fact, in H, the spouse is specifically stated as it's not included in the description of a related individual, which is amazing to me. It says, so wages paid to certain individuals as defined by 51I1. So it's not as defined by me or what we think or even logic. It's defined by 51I1. It says that are not taken into account for the purposes of ERTC. A related individual is an employee who has any of the following relationships to the employee's employer, who is an individual. Well, it doesn't include the owner. right? I mean, I get it. It's like, well, it's me, I'm related to myself, but that's not ever at all what this is referring to. And then it goes right here. If it's a corporation, so if the employer is a corp, then it goes to, well, who owns it? And it would be those that own more than 50%. And so another way to put this in is that if you have an ownership group and that individual owns 50% or less, this wouldn't apply. Now, what's interesting is I have a client and all 4 owners are related. And you have a father and a mother and a son and a son-in-law. And even though not one of those owners together own more than 50%, we had concluded, though, that indirectly the husband and wife owned the 50%, the son-in-law and daughter together owned 50%. And so when we look at this, you would have somebody that indirectly owns the 50%. And then if you include the son-in-law and the daughter, it's kind of one big group. And for family attribution rules, for any other rules that I've ever dealt with, they would all be related. They would all be related individuals. They would all, in essence, be considered, in essence, in a number of these rules, similar to almost at least one owner, and in some rules, 2 owners based on them being spouses. So we're going to have to look at that much more closely and reconsider, because as we look here, we do have a description of a child. We have a description of a son-in-law. We have a description, though, also of an owner and a spouse amongst all of that. So that's going to be a real mind bender to walk through. And, I'm really big on, I'm just repeating myself, that when we're reviewing the law, we just have to review the law. So again, if you go and you take a look, and I've got links to it, but you can all find it for free. Go to the CARES Act. It's 2301. And where you would look, right there is an E. Look through 2301. Look for anything related to related parties. Not seeing anything else. You can go to the FAQs on the IRS website. Go to FAQ number 59. You can Google that IRC section. You can Google the other IRC section, and you can do all the research yourself. But if you did have access to the seminar, or you buy access to the video and the seminar that you get immediately, I just have these links laid out for you. But I'll just have to tell you, I'm stumped. Today is February 3rd, and I'm a little stumped by it because it doesn't seem logical to me. It doesn't seem reasonable to me. But guess what? I've said time and time again on the employee retention tax credit, especially as it's related to determining whether or not you have a business that qualifies for the employee retention credit, whether it's essential or did it have a close down, facts and circumstances. And then we know this as well. The tax law is a tax law. It doesn't mean that it's logical. And so the only thing that throws me in it all is from the standpoint of the, pull it up right quick, is the indication here that the self-employed don't get it. Now, I get it. Self-employed are completely different in the sense that they have self-employment earnings. But we know that the self-employed is eligible to take advantage of the sick leave tax credit and the paid family leave credit. And when you look at those laws, it then specifically indicates that it includes everybody. This specifically states who it excludes. It doesn't specifically state that it includes the owner. It doesn't specifically state that it does include the spouse. But in the absence of saying, here's who it includes, we could infer that, well, if it doesn't exclude them, then they must be included. And a lot of times in tax law, that is what it comes down to. You go, well, it's saying this, and it specifically excludes these described individuals, but it did not exclude the owner. It did not exclude the spouse. So does that mean that the owner and spouse are included in the employee retention tax credit? When I look at it, here's the risk. You include the owner, you include the spouse, and you're reaping a tax credit for that. Well, that's no problem, because we know that for PPP, for sick leave and the paid family leave, those parties are able to pay themselves and reap a tax credit that goes along with it. So it's not that it's self-dealing or that it's self-serving. What I find amazing about it, though, is that if it is allowed, you would potentially have an owner, like right now, that if they know they're going to qualify for the employee retention tax credit, that they would go, you know what, I'm going to go ahead and pay myself. I'm going to either continue to pay myself, or I'm going to ensure that I'm paying myself when otherwise maybe I wouldn't. I'm going to create some wages because I can get a tax credit. Not usually how the tax law works when you can manipulate and create the opportunity for the wages. The reason that I think when it talks about, the more than 50%, well, the more than 50% would be somebody that has, in essence, full control, and they have their own determinations. And if you then don't have that control, then the logic is that that person who's the employer that's paying the wages, it would be more of an arm's length transaction, as they say. So I'm just going to have to leave it up to you on this one. The IRS, unfortunately, has not come out with a revenue ruling or a revenue procedure or what I would call an IRS notice. It has come out with some IRs. It's come out with its FAQs. The one thing to note is that the IRS specifically states that you cannot rely on an FAQ. You cannot rely on the IRS website, unfortunately. The law literally states that. You cannot go to the IRS later, or if you're challenged by the IRS, you cannot. You're not allowed. It's documented clear as day. You're not allowed to quote an FAQ. You're not allowed to say, hey, well, on the website, it said that I could do this. All we can rely on is the law. And the reason I'm saying that to you is that, well, if all we can do is rely on the law, then all we really can do is go to 2301E of the CARES Act. And then all we can do is go to 51I1, and then all we can do is go to 152D2. Well, that's all we really can go to at this point, because we have nothing else authoritative at this time. And I'll show you real quick, and then we'll wrap this up. But right here, you say this FAQ, right, is not included in the Internal Revenue Bulletin and therefore may not be relied upon as legal authority. This means that the information cannot be used to support a legal argument in a court case. So where am I at on this? Well, I have on all of my clients where they qualified, filed for the employee retention tax credit on their employees that they were not related to and not on the owners. While I do conclude here that owners and spouses are not excluded, I'm not seeing that they're included. And then based on, which I challenge many times in other people's research, when they say, well, but based on logic or based on my experience, here's my conclusion. But based on my logic and based on my experience, I'm concluding for now, until we get concrete information from the IRS that we can rely on, that the owner and the spouse would not be included. And I've already explained that why. So what I would say is that if you conclude something different, then that's all we can do. That's all we can do. We can take the information and draw our conclusions and then act on those conclusions. And for now, my conclusion is what I just indicated to you, but I am noting that if the IRS does come out and indicates in a much clearer way than this that the owners and the spouses can be included, well, then it's pretty simple. We file a 941X and we go back and we get that tax credit for the client, so it's not lost. So for me and my clients, we've taken the approach that we know we qualify for, we know we get those credits. And while I could have taken a position of, well, the owner and the spouses are not excluded, so we're going to include them, I decided not to take that position, because if you had two owners or a spouse, so you could have owner and a spouse or two owners and a spouse, whatever, and there's $5,000, $10,000, $15,000, $20,000 in tax credits. If you take a tax credit, you don't go to jail if you got to pay it back, not even really in trouble. You would just have to pay it back. You got some penalties and interest, and that's all that's really being risked is penalties and interest. So with several of my clients, I'd indicated to them that we're not including them, we're not including their spouse, we're not including the kiddos that are working in the business, like working in the business, right? Not including them, any kiddo, any relatives, we're not including them. But that when the IRS would make this more clear, because they're going to have to come out with some rules and regulations related to this at some point, okay? It's kind of shameful that they haven't already. All we got to do is file a 941X. Yes, it's a little extra effort, but then it's sure-footed. We're on concrete ground that we can then go and get that credit. I would rather work through a situation like that with my client where they know we might get some money later, but for now we're going to get what we know we can qualify for, and then when we feel comfortable to take the rest, okay, well, then we will. So because it's new, it's not something we've dealt with before. When we're talking about the employee retention credit out of the CARES Act, because we only have FAQs to rely on, that is why I've taken that safer position. And it's to ensure that the clients are not having to pay it back and are not having to pay back with any interest or penalties. So it's about knowing the law and then just following your gut on it. So hopefully I've given you enough information. You'll be able to draw your own conclusions, and hopefully the IRS will come out with something, and by golly, if they will make it clear that, yeah, these are the ones that are excluded, and yes, these are the ones that are included, owners and spouses, then boom, my clients are going to be excited because there will be some additional money coming back to them. My hunch is it won't work that way, but we'll see. All right. Hey, thanks for tuning in. If you made it to here and you're not a subscriber, you need to subscribe. If you're interested in the video, I did the seminar. It was 2.5 hours. It has a PDF presentation of the PowerPoint and then all of that information that I had shared with you at the beginning of the video. There's a link in this video where you would be able to go and get immediate access to, I'm pulling this up, you'll be able to get immediate access to the seminar, and you'll be able to get immediate access to all of these materials. So you'll be able to get immediate access to all of this, which includes executive summary, which has been updated, worksheets, Excel spreadsheets, and a lot of it is also just taking the links and putting it in a combined area. And then it does include this private video that's not public on YouTube, which is about my research of why I think more businesses are going to qualify for the ERTC than many think, many more than many think. So, all right. Hey, thanks for tuning in. I'd love it if you'd subscribe. And then don't you ever forget, you've never met a CPA quite like me. All right. Hey, have a great one.